Right. Now, my final segment today is a story about a deeply controversial and emotional case that has captured the national attention. The family of 19-year-old Sudiksha Thirumalesh, who tragically passed away while fighting against doctors' attempts to withdraw her treatment, has successfully overturned a court ruling that deemed her incapable of making decisions about her own care. Now, this is not the first case that we've seen of this over the past couple of years. There have been a few other cases which I've covered here on the Freeman report, but this one is unique in the sense that it is a very, very sad story, by the way, because she has passed away, but the family has actually had the original court ruling overturned. So to talk all about this, I'm joined by Roger Kiska, who's a legal counsellor for Christian Legal Centre, and he actually represented the family in this case. Welcome to the Freeman Report, Roger.
Yeah, thank you so much. I'll just clarify that I wasn't the barrister in the case, but Christian Concern did support the family throughout the proceedings.
Okay, thank you for that clarification, Roger. Roger, tell us about the story. Tell us about the case and what actually happened to her.
Yeah, absolutely. Sudiksha was a young lady who had mitochondrial disease, which is a degenerative disease. It attacks the muscles. And it was quite painful and tragic, and she was dealing with it with corticoid treatment and things like that to slow it down. And she and her family had read about treatments in Canada and the US where they were doing trials on mitochondrial disease because it's still a relatively unknown phenomenon. There's no cure for it. Nevertheless, her doctors treating her in Birmingham thought that it wasn't worth her living anymore. So they went to court to get an order saying that she wasn't mentally competent to make her own medical decisions based on the fact that she wouldn't accept their diagnosis, that she felt that there was hope in these trials. And based on that alone, this is despite the fact that the Court of Protection had two consultant psychiatrists who had said this young lady is fully competent. She's aware of the risks and what she's saying, and she should be allowed to make her own decisions. The Court of Protection said, we're going to listen to the clinicians, even though they're not psychiatrists, and we accept the argument that she's mentally competent because she won't accept her diagnosis. And because of that, that led to her removal of treatment and ultimately her death.
So what were the arguments that were represented to the court that have had that original judgment overturned then?
Well, I mean, it went to the Court of Appeals, who reviewed the law and looked at the precedent that was being followed by the Court of Protection and said, I mean, this is a procedure that the Court of Protection has used in the past. It's just not the correct way to interpret the precedent. So Section 1 of the Mental Capacity Act, 2005, states that a patient has the presumption of mental capacity, and that has to be overturned in order to override her wishes or his wishes in that case. And the judge in this case, or the judges, it was a majority opinion written by Lady Justice King, said that clearly the court should have listened to the psychiatrists. They didn't even factor that information into their judgment. And this young lady was fully aware of the fact that she was suffering, that there wasn't much hope, but she wanted, in her own words, and this was repeated by the Court of Appeal, to die trying to live. And so they overturned the decision and commented on her bravery. And she will be, for future generations, for people in that situation who are deemed to be mentally incompetent solely on the basis that they disagree with their doctors, that presumption is now gone because of her and her family fighting this case and winning that precedent.
What impact has this had on the family? I'm sure that you've worked closely with them. What's it been like going through this, and how do they feel now about this court judgment?
Well, I mean, the whole thing is incredibly frustrating. The Court of Protection is very secretive. And you can imagine if you're the parents or siblings of a child who you know is mentally fit. She was doing her A levels. She was a fighter. And for them not to listen to her, for them, just as egregiously, for the court to put on reporting restrictions. So she couldn't even have a real name out there. And this is a family who's trying to crowdfund to get the money to go to Canada for those trials. So even had the court found her mentally competent, that reporting restriction prevented her from earning the funds, raising the funds to get that treatment. So it was a double whammy. You can imagine Sudiksha's position where she's reading, these stories from around the world which are supporting her and grieving for her, and she can't even say that it's her. It's like being in the water surrounded by people who want to help you, but you are not allowed to call out. So the family's been brokenhearted. They're grateful for the fact that she gave this gift of this precedent to the future people in her situation, but nothing will ever bring her back. Nothing will ever undo what the Court of Protection did.
And is this a common sort of approach for the court to say, well, look, clearly there's not much hope. So the fact that the patient is showing hope means she's clearly not in full control of her her mental faculties. Is that? I mean, that seems like an incredible way to approach the question about whether somebody is compos mentis or not. Just the fact that they don't agree, they just have a different opinion, or want to take a different approach to the court. Is that something we've seen? Is it commonly used in law?
The idea is we have literally no idea, and that's because of how secretive the Court of Protection is. So it might be common, it might be uncommon. We don't know. We know that Sudiksha was one of a kind in that she was willing to raise her voice and fight those reporting restrictions and fight that finding. In the vast majority of these cases, and you mentioned that you've reported on these cases, the Archie Battersbys, the Alfie Evans, the Charlie Guards of the world, they're already unconscious. They're not able to speak up for themselves like Sudiksha was. So the answer is we don't know. What we do know is that this precedent has changed the situation for those people who will go through this in the future, and will hopefully give them a voice to speak up for their own rights.
Yeah, and has the court, have the judges involved in the original judgment, have they been forced to say why they didn't listen to the psychiatrist? Because it seems like a bit of a odd one, that, because, who better to ask if somebody is compos mentis or not than an actual professional in that area of medicine?
I mean, the whole case is like a Hollywood drama in a lot of ways, because the sitting judge who made those decisions, Mrs. Justice Roberts, passed away suddenly and unexpectedly. So the sitting judge on that case is no longer with us. But the way the cases go is that the court, the higher court overturns the lower court. There's no sanction for it. I mean, it certainly goes on their record, and when it comes to future promotions to higher courts, that's factored in. But there really is no form of discipline when the court gets it wrong. It's just that the family gets another day in court through the appellate process.
And presumably there is, not that this would be the reason that the family were taking this judgment to the higher court, but presumably now there's going to be some kind of penalties for the NHS or for those involved. What are they?
Well, I mean, the family is considering every possibility. The NHS, what they would argue is that they were following the law as it was in place and arguing the precedents as they thought they were fit. That doesn't certainly clear them of malpractice in how they treated her, how they removed her care when she was fully mentally competent. So we'll wait and see. It is just tragic. There's no winners in this. Everyone is a loser, and it's just shocking to me that the NHS trust, the Court of Protection are so bleak in their outlook that they couldn't even find hope in a young girl who wanted to live so badly and couldn't understand why she would want to live.
And what is the precedent that's being set with this case? Because, of course, we've got lots of issues, I think, to do with end-of-life care at the moment. I've talked about it a lot on this show. We've had people on that have, they've had treatments in hospital which they didn't want, which they hadn't given permission for. So there is a kind of quite a wide sort of platform of issues this relates to. But what is the specific precedent that this case sets?
Well, the specific precedent is it kind of resets the presumption that's already written into law in the Mental Capacity Act, that you have a presumption of mental capacity, and disagreeing with your doctors and how they want to care for you or not care for you does not override your mental capacity. That there has to be much more than that. But more than that, we are calling, Christian Concern and Christian Legal Center are calling upon the government to start an inquiry into these types of cases, into the secrecy of the Court of Protection, into the fact that they're using reporting restrictions as a sword against the people who are having their lives threatened, just to protect the hospitals and not the patients, and just to reform a system that is doing so much harm, because we don't have de facto euthanasia in the UK, but this is de jure euthanasia. When you remove the care and the life-sustaining treatment against that person's wishes, that is euthanasia. Whatever you want to call it, that is euthanasia.
And with that, these media restrictions, are they clear in the courts that actually put them restrictions in place, that what they're doing is protecting the hospital? Is that actually what they're saying? Because to me, that seems, again, ridiculous, because this is a judgment of public interest, because it could be any one of us that is in that situation one day.
Yeah, that's I agree with you 100%. Those arguments have been made in proceedings. There was a Supreme Court case very recently that we're waiting the outcome for, where they're saying these reporting restrictions are overly broad, draconian, and they don't serve the public interest, because these end-of-life cases, with all the media attention that they have, is a huge area of public discussion, and the people should have a right to get information about it. The Court of Protection is suggesting that if you put the name of the clinicians out there and the trust, that it puts the safety of the doctors caring for that person in danger, and that's the reason they give behind it. But there's no balancing of it. It's almost an absolute right of protection without balancing the rights of the patient who's being affected by the decisions.
Yeah, of course. Can I just ask, so you work for Christian Legal Center. What kind of work do you do? Do you work on other cases related to this, like end-of-life care and that kind of thing?
We've done a number of these cases. We were there supporting Alfie Evans, Archie Battersby. We do any number of other cases involving religious freedom. So in employment scenarios, for example, it's a wide range of activity focused on protecting the right of people of Christian faith to live out their lives, but also the larger questions of the right to life from conception until natural death.
Yeah, the reason I ask is we have nearly run out of time now, but I would like to talk about this more, because it seems like the overall sort of argument in the UK is moving towards, euthanization, legalized euthanization. I'd love to talk more broadly about that with you if you'll come back on the show at some point.
Absolutely. Yeah, happy to do so.
Fantastic.
Near and dear to my heart. Yeah.